city and a player in the sector, and could not therefore be fairly regarded as a body that should continue to perform this function. He was also of the opinion that it was, if this were to be challenged under the Fair Competition Act, he believes the challenge will be successful, since the resolution of this matter would require a policy decision. It was referred so I could address it. The issue of the need to regulate the LNG market also formed part of the discussion, since it was currently unregulated. Ms. Lewis from the OUR indicated that there was a draft bill emanating from the MSET on which the OUR had provided comments. A request was subsequently made for me to provide an update on the progress of this bill. It was agreed at that meeting that July 19th, 2023, 2 p.m. and Tuesday 25th, 2023 at 10 a.m. would be the scheduled meetings. So as it relates to the issues that were deferred for my attention, I will have those dealt with and make sure that they are available for the next meeting. And therefore, I think we have the ratifications of decisions taken by the committee at the meeting held on May 18th. Maybe we'll ask Ms. Campbell to just take us back and just make sure that what needs to be ratified can be done by the members who were present there. And then, of course, a presentation from the OUR.
Minister, probably just before you go on, I wanted to raise one of the matters that you just spoke about. Because remember, it is not the first time, or the second time, or the third time I had raised it, which was that we were operating in an environment, an unintended environment, where we only have one supplier of natural gas. And it was always my contention that prior to now, the intention was to ensure that we had in place proper regulations to enable a more dynamic LNG sector. And I have been at pains to suggest that drafts were done and they were really on the verge of being promulgated. And you and your peers had done some checks and you didn't find it. So I was so pleased to hear that the OUR had actually reviewed some of those draft regulations. So I think it is really a matter of high priority that we try to get that before the committee, because if we can deal with that issue, we would have done well in terms of enabling the framework for competition in relation to the supply of natural gas.
So, member, I'm happy to as well, because as I indicated at the last meeting, we had checked Cabinet Office and checked with all through the ministry, and we're unable to find anything. So now that that is so, we'll be in touch with the OUR to get that, so that we can review that and, of course, obviously opine on it. And I will do that for the next meeting. Okay. As we're coming down, we're winding down to the end, as we know. So all of those matters I'd want to make sure we are dealing with. So I know the OUR is on, so I think they have heard me, and also Ms. Campbell, and also the issues, Ms. Campbell, that have been referred for my attention. Please have them put to the PS for me immediately, if that has not been done so already, because I'm just reading it now and realizing that nothing has come to me in relation to those two matters. All right, so Ms. Campbell, you want to deal with the ratification of the decisions by the committee at the meeting on the 18th, as I indicated earlier. Not hearing you.
I'm trying to bring up the document, Chair. May I have a moment, please?
Yeah, no problem. You heard what I said about the OUR document that Minister Paul had mentioned, and the other two matters that are in my brief notes. For the information to be put forward so we can have a discussion on it.
Yes, Minister. Hmm. The document is not opening, Minister, so I'm trying to get it from my phone.
You want us to move and give it some time and move on to the OUR presentation?
It's coming up now. Minister. So on section 21, concerning renewable energy. Section 21, renewable energy, the ministry's position was that the provision as it stands in the Act is sufficient to address any renewable energy needs that Jamaica will require, and it doesn't fetter the powers of the minister to make such decisions in consultation with the OUR. The OUR had a proposal in relation to section 21.1. They were recommending that the express reference to feed-in tariff be reconsidered in the legislation. The ministry's position that it presented to the Joint Select Committee is that it does not recommend the removal as proposed by OUR, because the law does not require that its use or its application be mandatory. So therefore, the OUR is at liberty, based on the circumstances presenting, to opt to use the feed-in tariff option, as well as not to use it. The ministry was also of the view that there was a possibility that other technologies may require the use of feed-in tariff to ensure that the low cost or declining cost of one technology does not preclude other technologies from the competitiveness criteria. The committee accepted the ministry's position on this matter. In relation to section 21, subsection 2, the OUR had recommended a redraft of the provision to provide some clarity. The ministry indicated to the committee that it may consider and accept the recommendation of the OUR to insert the phrase "by a licensee" between the words "generated" and in the first line. 2, insert the phrase "taken by the system operator to replace," "granted access," and the word "refuse" to replace they were denied. The ministry also recommended that in section 21, subsection 2, the removal of the word S from distribution in the second line. And also there was a recommendation for the addition for battery storage to support reliable energy generation from intermittent renewable systems. The committee agreed to the correction to the grammatical error, and Mr. Jarvis recommended that battery storage should be replaced by a long duration energy storage to capture other types of storage. And the committee accepted the proposed amendments with the adjustments suggested by Mr. Jarvis. I hope I'm not mispronouncing that person's name. WRB Energy submitted a recommendation to the committee. The committee did not accept the changes proposed. The ministry's response is that the policy position does not align with any of the recommendations put forward by WRB Energy, for the reason that the system planning considerations have determined that the renewable energy capacities are adequate to prevent instability to the system, and the cap for commercial generation in respect of net billing is already set. Well, that's the ceiling at 100. Moving on to section 22. The OUR suggested in relation to the single buyer, hold on, let me see. The OUR suggested that the subsection 2 in subsection 2 that the words electricity supplied by it or by any other person to the consumer can be replaced with electricity system. And they have suggested a redraft to say it shall be the duty of an electricity licensee to ensure that it does not commit an act of omission that will adversely affect directly or indirectly the security and stability of the electricity system. The ministry did not support the recommendation. Because the single buyer is a supply license, hence the phrase suggested for the removal should remain to capture that duty as expressed. And it was suggested that it may be that the phrase or to the electricity system could be added at the end of the sentence to capture transmission and distribution licensee. So what the committee is asking to ratify, the ministry So the ministry was of the view that deleting supply, and this was the decision taken by the committee, was of the view that deleting supply as recommended would mean that the duty of a supply licensee would no longer be captured by the provision. The ministry therefore proposed that in addition to the other wording, the phrase or to the electricity system should also be added to capture transmission and distribution licenses. The ministry did not, however, have a proposed redraft of the provision so that members know exactly what it would say. The OUR did not object in principle to the ministry's proposal to add the phrase or the electricity system, the end of the provision, but were still of the view that the words supplied by it to consumers were superfluous based on the meaning of supply, but recognized that this was a drafting issue. The committee accepted the proposed amendment, but requested to see the redrafted position would read. In relation to section 22, subsection 3, the recommendation was to close the parenthesis, and the committee agreed to that.
Ms. Campbell, is there any of them that was not agreed on that needs to be a decision needs to be taken? If the ones that are agreed already, that the committee agreed on, we don't need to go over those. We just need to know what are the outstanding matters that need clarification or need to be ratified.
Chairman, if I could add some clarity,
Please.
why it's necessary? Because at that meeting there was no quorum, so whatever decisions were taken are not really binding because the quorum wasn't present. So
Okay, I understand. Okay, understand. All right.
Okay, so
without just to be clear, so without the quorum, those that were there took decisions pending the ratification.
yes, sir, because you had started with a quorum and then the quorum was lost shortly after. But usually there is provision for the meeting to continue, but the proviso is that the decisions taken would have to be ratified when there's a full quorum. Because once you lose a quorum, it becomes an informal meeting.
Okay, understood. All right, go ahead, Miss Campbell.
okay, so section, in the interest of time, section 27, the committee agreed to the recommendations. Section 28, the committee agreed with the OUR's recommendation as well as the ministry's additional recommendation in relation to making adjustments to provision in relation to the offense of cutting electricity line. The recommendations were to add to the offense any interference with transmission, distribution line, or electric work, and also for the offense to capture an intent to disrupt any transmission, distribution, or supply of electricity being an offense. The JPS presented some recommendation in relation to protecting the electricity infrastructure from cyber attack. And the ministry recommended that the provisions in the Cybercrimes Act are sufficient to capture any offense in relation to the electricity infrastructure. The committee accepted. that is the extent of it. So it's from the ratification would require the committee decision from section 21 to section 28.
So those are the ratifications that are required.
Yes, Minister.
Members, any concerns or comments in relation to Ms. Campbell's presentation? All right, so with that, I take it we can ratify it by virtue of the fact that there's no objection. All right, thank you. All right, so we're going to go straight into the OUR. Thank you, Ms. Campbell. OUR, over to you.
Good afternoon, members. We would have submitted some things in writing, and we will just propose to go through those in terms of some additional comments that we would have had on sections that would have already have been addressed by the committee or examined by the committee, as well as a few others which the committee has not yet reached in its deliberations based on the matrix that MSET is going through. And so when I reach that point, Chairman, if I may, I will just seek your guidance as to whether you wish us to present on those issues or whether we should wait until the committee reaches that point in the matrix. First of all, in terms of section 2, going back to the interpretation section, in the Electricity Act, there would have been some discussion regarding the inclusion of a definition of trigeneration. And I think that came out of some proposals that would have been submitted by the private sector organization of Jamaica. The ministry in its deliberations accepted the inclusion of a definition and proposed that definition as trigeneration means the production of a cogeneration system and an absorption chiller, which converts gas into electricity, heating and cooling. The waste heat from the cogeneration system is converted into chilled water for air conditioning, refrigeration, or other cooling purposes. From the OUR's perspective, we do not object to the inclusion of the concept of trigeneration since the Act already recognizes cogeneration. We would, however, propose a more generic definition. We find the definition proposed is very, very specific, and we think a more generic one will ensure that all modes of trigeneration are contemplated and not only those that are specifically set out in the definition. So we propose trigeneration means the simultaneous production of electricity, useful heat, and cooling all from a single source. And that will actually, it's quite similar to the definition of cogeneration that's already in the Electricity Act.
And
Also,
I would take it that would include the activity of regasification, that process that takes place when you're shifting back from the liquid to gas, and the cooling that enables.
right.
Okay, so I suspect that was what they were trying to catch, but you have broadened it now to take into account other types of energy that could come from such activities.
Right. Yeah. Indeed, member. So what you'll find with cogeneration and cogeneration being two byproducts, cogeneration 3, is that essentially there is some process, an industrial process or a manufacturing process that actually has as a product electricity and heat, or in the case of trigeneration, electricity, heat, and cooling. So I think that's what should be captured. In terms of grid parity, Again, coming from a proposal from the PSOJ, the ministry had proposed a definition of grid parity, which is grid parity means the manner in which an alternative energy source can be costed at a net present value greater than that of the generation set. Levelized cost is the net present value of the capital investment for a generation set to produce electricity. Our only comment there is that the concept of levelized cost is not only restricted to capital investment, but also operation costs. So if that definition is accepted by the committee, we would suggest that operation cost is also included. So the part of the definition that speaks to levelized cost could read, levelized cost is the net present value of the capital investment and operation costs for a generation set to produce electricity.
I agree with that.
Okay. Still in section 2, the definition of single buyer, the OUR had proposed the inclusion of a reference to cogeneration. Well, let me just quickly read the definition of single buyer. So single buyer means the licensee whose license obligates it to purchase electricity generated by independent power producers and persons having net billing arrangements. And so the OUR had suggested that we also make reference to purchasing energy from cogenerators as well. The ministry expressed the view that cogenerators appear to fall within the description of independent power producers or IPP arrangements, and therefore there was no need to make special mention of cogenerators. Our concern is that while we would agree that persons who are licensed to produce energy using cogeneration facilities are treated as IPPs in that they will enter into power purchase agreements as IPPs do with JPS, based on the definition of independent power producers, they are actually not contemplated as an IPP. So in the Act, independent power producer means a licensee that owns or operates facilities for the generation of electricity for use primarily by the public, and that is not the same legal entity as the single buyer. So essentially, an IPP is an entity that its core business operation is the generation and supply, well, not supply, but certainly the generation of electricity. As based on our discussion earlier on cogeneration and trigeneration, quite often these are entities that are set up for some other primary purpose that is really not electricity, but the generation of electricity is a byproduct. And often there's an excess of supply, and so it is efficient for them to enter into arrangements with JPS to sell that excess supply to the grid. So for example, there may be an entity where its primary purpose is the production of bauxite or processes in relation to the processing of bauxite. And as part of that manufacturing or industrial process, electricity is generated, and therefore they enter into a power purchase agreement to sell that electricity, excess electricity, to the grid. So a cogeneration plant and a trigeneration plant would not necessarily be considered an independent power producing plant based on the definition in the Act. So again, our suggestion is that in the definition of single buyer, we actually incorporate these other electricity generation processes that are not contemplated. So it could read, single buyer means the licensee whose license obligates it to purchase electricity generated by independent power producers, self-generators having net billing arrangements, and persons who are licensed to generate electricity other than for their own use using cogeneration, trigeneration, or other arrangements.
Ms. Riley, one of the things that we have been grappling with is this concept of single buyer. Mm-hmm. More so because many of us are thinking long-term. Yes. When there is no license that restricts us as the current one does now. And there is greater scope for competition. There might be in that milieu microgrids being established. You might have people who operate in the exclusive economic zone, for example, doing their own transmission and so on. And we thought it might be useful now to expand on that definition of single buyer to take into account a different scenario that, because we are making legislation not just for the next 3 years. I'm hoping that after this exercise, we wouldn't have to review this law for some time. And I wondered if the OUR had pondered on this issue. And I know the minister is actively contemplating it, but it is my own view that at this stage, we should be looking now at a broader concept to include other types of competition that we are restricted from doing.
Yes, member. So it is something that has been in our scope of contemplation, particularly now that we are looking at the end of JPS's license in 2027. We are very cautious in that we do recognize that it is a policy decision to be made that will require significant examination and perhaps, not perhaps, but certainly consultation in the industry to see really what will the industry look like post 2027 or post some other period. And so it has been our constant song, for example, that in the current review, while we do recognize that the construct in the industry now is a single buyer, we also ensure that the provisions are drafted in a manner that it contemplates other possibilities where you could potentially have multiple licensed persons to supply, or you may have someone other than a single buyer who is in charge of transmission or distribution, etc. So we do recognize it is a significant policy matter that has to be discussed. So our position is, while this legislation could continue, well, as of necessity, have to recognize the single buyer, because that is the position, at least up to 2027, that there should be sufficient flexibility in the provisions that can contemplate other licensees for the other components of supply, transmission, distribution.
All right, so I'm sure the minister hears you clearly. So we'll have to come back to that issue.
Very clearly, Minister. And as I said in the opening remarks, I know that this is waiting on me. I will definitely get it done and come back to the committee for sure.
Okay. In section 6 that deals with standards of the single buyer, we had noted from the ministry's matrix that their position on certain proposals made by JPS were deferred pending the OUR weighing in on the issue. So in its comments on that section, section 6.4 in particular, JPS suggested the codification, of international best practices to be used in the setting of tariffs in the Act. And they also suggested the inclusion of certain specific principles. These included that rates should be cost reflective, rates should be non-discriminatory, rates should comply with all applicable rules, regulations, or licensees' license. Rates should not threaten the financial viability of the licensee, and rates shall be transparent in the sense that all choices of principles, policies, calculations, methodologies, and models used by the OUR shall be disclosed. So we are really supportive of our rate setting to be transparent and to take account of principles that are deemed to be industry best practice and ensure that the very basis upon which JPS's tariff should be determined are covered as are set out in its license as well as in applicable legislation. We don't necessarily agree with JPS, however, that these principles as they propose should be set out in the Electricity Act as suggested. First of all, in our tariff setting activities, we are guided by benchmarking principles, as well as the requirements that the determined tariffs should allow for prudent recovery of costs and an opportunity for reasonable return on investments. But we also recognize that there is need to have some flexibility in terms of the principles that we do apply, because while these are principles that have broad application across sectors, there is need for sufficient flexibility to ensure that modification to these applications are done to address things that are specific to the sector and specific to the Jamaica jurisdiction. So we need to have flexibility to update the principles or modify them as needed without them having, without us having to come back to Parliament every time to make those adjustments. And that would be the result if they're hardwired in the legislation. We think it's important to point out that JPS's license actually prescribes the procedures for tariff setting and actually sets out in detail the factors to be considered for determining its rates. And while we do agree that there is the need for some refinement, we think that the license, for example, would be the appropriate location for any such refinement, particularly since it is specific to JPS and specific to JPS's rates. And also, some of the tariffing considerations are very specific to JPS because of the nature of the structure, not only as the sole supplier of electricity, but it is also a virtually integrated company. And so we have to ensure that the tariffs that are determined for that particular company take account of the fact that they also have other activities in relation to their business, which relate to transmission, distribution, and generation. In an amendment to the Office of Utilities Regulation Act, there were other rules that were prescribed that should be taken into account when we are determining tariffs for the electricity sector. And among those are that the tariff should be according to the provisions set out in the electricity licenses, as well as accord with any policy directions that are issued by Cabinet. We have said before that our preference is that that particular amendment either be reflected in the Electricity Act itself, or there be a specific reference in the Electricity Act to that amendment, so that a person who may not think of looking at the OUR Act when they're examining principles with regard to electricity tariffs will at least be made aware that there are other factors that are to be considered by the OUR in determining electricity tariffs that are located elsewhere, meaning outside of the Electricity Act. We should also point out that that amendment also requires the OUR to take into account the interest of consumers, Jamaica's economic development and the best use of indigenous resources, also the development of special tariffs for particular purposes. And therefore, it's really important to ensure that those things are reflected in the Electricity Act or an express reference is made to those. So in light of all of these considerations, which are matters that are even outside of or not specific to JPS, there is need for the flexibility of the regulator to apply appropriate regulatory principles so that not only the matters that are in direct reference to JPS's recovery of costs, but also that relate to the interest of consumers, Jamaica's economic development, etc. All of those are taken into account, which we don't think can be done by hardwiring certain principles in the legislation. We have no objection to the general principles outlined by JPS regarding cost reflectivity and non-discrimination. But it is our view that these principles are already captured in JPS's license, as well as the regulatory principles that the OUR already applies. Also, in terms of the whole point of transparency and accountability, it should be noted that our decision-making generally and specifically with regard to JPS's tariff is subject to review by an electricity appeal tribunal that's established under JPS's license. That tribunal has the power to not only apply judicial review type examination of the OUR's decision, meaning, was it reasonable? Did we take account of appropriate factors? But the tribunal can actually modify or superimpose its own decision over the OUR's decision. So it's a very powerful entity. And so that ensures that there is some accountability from the OUR, and our decisions on JPS tariffs are subject to review. Also, as a public body, the OUR is obliged to give reasons for its decision-making. And so, and we do, we issue very extensive tariff determination notices, over 100 pages, that detail the reasons for our decisions. And so in light of that, we believe there are checks and balances, both in JPS's license, in OUR's practice of publishing its reasons for decisions, and the fact that our decisions are subject to review to ensure transparency and accountability in the OUR's tariff-making function. So in light of that, we do not believe that the tariff-making principles should be hardwired in the Electricity Act.
May I comment, Minister?
Go ahead, Member.
Yes, the function of tariff review by the OUR is probably the most important regulatory function of the OUR. Certainly the consumers in Jamaica, I think, will feel that way. So I do share sympathy with the points that are being made, and that you shouldn't have hardwiring taking place in legislation. So I don't have a difficulty with that. But, as you were speaking, I was in the process of asking the minister some questions in Parliament. And perhaps I probably won't need to go there if you could just explain for me whether or not the concept of universal service is applicable still to the JPSCO, and is that embodied in the tariff regime that now exists? There was a time, Minister, you're aware, I think in fact, the function of rural electrification has been brought back into your ministry. It used to be at the ministry after NESA was closed, it went to local government, and it's now brought back. And there is the requirement for universal service for economic development. And the REP used to work in close tandem with the JPS to extend lines, but for the JPS to reimburse the government after such extension is done. I am not too sure if that activity is still recognized by the OUR. So I know it is really an aside, but I'm very interested in that, and you could prevent the minister from having to face me in Parliament on it.
Well, I dare not step into the minister's shoes, but I will do my best to answer questions from the OUR's perspective. So in terms of universal service, so the desire to ensure that electricity is accessible across the island of Jamaica is a concept that is contemplated by the Electricity Act. And it is facilitated by JPS's license to the extent that it has been granted that license and the obligation to supply for the entire island of Jamaica. And there are provisions that are made for other entities to facilitate, you had made reference to line extension, but for rural electrification. So there is in fact a body that is established that can facilitate rural what's the matter with me today? Electrification. And there is a facility that's contemplated in the JPS license for instances where that entity does establish the necessary infrastructure, then it is taken over by JPS based on various terms and conditions. And I don't know if there are any of my team members who have more detail in terms of how that works, but they can feel free to jump in if they do. Also, there is a recognition that sometimes there is need for financial support for this as well. And if you do look at the provisions that speak to the System Benefit Fund, that kind of provision of supply to unserved areas is contemplated as a potential beneficiary of funds from the System Benefit Fund. So as far as I'm aware, that does continue. I don't know if there are any projects currently in train, but there are steps being taken to facilitate the extension of electricity access across the island.
Well, the reason why I asked, and it's particularly for the minister, so, and I'm so sorry to bring it up here, but I think it is, everything is everything. The REP used to extend these lines and they would be reimbursed over time. And it would enable the government to do further investments in expansion in the grid and in doing house wiring and so on. And it is my understanding, Minister, that the reciprocal arrangement, which is to recover from JPS for so many of those extensions that were done, that is not being, that's not happening, and it might very well be shortchanging your capacity and ability to do rural electrification and indeed some of the urban regularization that we've been dealing with recently. So I did want to ask you about that, and probably, you know, you could look at it and come back to us sometime soon.
Sorry.
Noted, member. And yes, you are correct. It has come back to us. And of course, we know that JSIF was also doing some line extension, and it is my intention to have dialogue with JPS. But thank you for raising what you raised, because I had not heard of that. So I'll check into what really was the original agreement, and now that it's back with me, see where we go from there, for sure.
Chair, if I can make Courtney Francis from the OUR, just to add to what Shane had said, and to support some of the arguments that Member Paul was raising. A few years ago, the ministry had done a study that they call total electrification for the entire country. And at that time, the OUR was collaborating with the ministry on that development. But the last update we got was that process was shifted to the Ministry of Local Government. So I don't know if you might want to just check with them to see what has been happening where that is concerned. But that study was done, and it was commissioned by the Ministry of Energy some years ago, about 2-3 years ago.
All right, thank you, Mr. Francis. I will note this, and if necessary, I'll have further discussions with you to get clarifications and Mr. Riley.
Thank you very much.
Just to continue.
Verified.
Yes. Under Section 7, so that sets out the ministry's responsibility for system planning. And there's an important issue of the integrated resource plan. It is a very important component to the JPS tariff process, as well as to the procurement of new generation, in that it provides a baseline in terms of what the avoided costs should be, which is a critical factor in assessing the value of JPS's exercise of its right of first refusal, as well as assessing whether we're getting value for money in terms of any new generation proposals that may result from any competitive bidding that's undertaken by the GPE. In the third schedule of the Act, it makes mention of this avoided cost being updated every 2 years. And the IRP is actually the source or the place where the avoided cost is computed. And therefore, it is our suggestion that the Act contemplates the IRP being updated every 2 years. So if that is accepted, the suggestion is that that can be added to Section 7 of the Act.
Well,
Section
the only question I have, and the minister, I'm sure will agree with me, is we have been trying to get this IRP in place, and we did get IRP 1, and it did take a much longer period of time. And we now have IRP 2. It's just when you put it so hard and fast in legislation, and you are unable to meet that deadline, it makes a mockery of the law. Would you contemplate a longer period, 3-4 years, instead of hard and fast 2 years? Because we have seen where it has taken us quite a long time to get the first IRP in place.
Shani, I don't know if you want me to just try and talk a little bit about that. But so one of the reasons why the OER tend to be inclined towards a 2-year revision is because when we do planning, the assumptions, they get stale very quickly. So if you are assuming demand today, by the next couple of months, that demand might not be that relevant. So we believe that a 2-year time frame is a reasonable timeline to have such studies updated, because all the parameters in terms of cost, demand, other assumptions, they tend to expire quickly. So a 2-year, I understand the constraint in terms of the resources and so on, but if you really want to maintain the efficacy of the planning process, I think a 2-year timeline is a reasonable construct or arrangement to look at.
All right, point taken.
And just to add, the Act already contemplates that at least the avoided cost has to be updated every 2 years. So it may not be a full-scale total review of the IRP, but there may be components that can be updated on a shorter basis. So Section 20 is the section that deals with the procurement of new generating capacity. So that section addresses the exercise of the generation procurement entity, the GPE, going out for competitive bidding for new generation, as well as JPS's exercise of its right of first refusal, which we call the ROFO. In its analysis, the ministry had suggested that subsection 5 of that section would need to be modified to state clearly that a subsidiary of JPS is barred from replacing its plants using the ROFO that's provided for under the Act. But then we also noted in its analysis that it also suggested, and I quote, if the removal of section 20 subsection 5 would serve to eliminate any ambiguity, there is no objection to same. So we were a little concerned in that section 20 subsection 5 has an express prohibition on the exercise of the ROFO by a subsidiary of JPS. And we propose that that express prohibition be included. The ROFO is a special privilege that has been accorded to JPS, and it gives it the opportunity to preserve its original generation capacity that would be in its control up to 3 years after obtaining its electricity license. This is not a privilege that is accorded to any other electricity generator in the sector. And so we would caution that that limited application of a ROFO is eroded by allowing a third party, which is a subsidiary of JPS, would be a third party, to also indirectly or separately have that power to exercise ROFO. It is our understanding that it is only in very limited circumstances that JPS would be permitted to exercise its ROFO through a subsidiary. And you can have a look at subsection 8 of section 20. And it is our understanding that once JPS exercises the option through a subsidiary, any future ROFO with respect to that particular capacity is lost, as the capacity will no longer form part of the assets and be under the control of JPS as part of its aggregate generation. If this reflects the understanding and policy of the ministry, we would therefore not recommend the deletion of the prohibition in section 20, subsection 5, but rather the retention of that clause with appropriate modification. So if JPS is permitted to exercise its ROFO through a subsidiary in accordance with subsection 8 of section 20, then it should be clear that that subsidiary does not then gain a ROFO with respect to that capacity.
So you're speaking of the South Jamaica plant.
Any subsidiary of JPS.
Okay, very well, and the point is well taken. Yes, because I was going to ask the question: does this concept go in perpetuity? And clearly, it cannot. And as a JPS is now changing out its system using private power suppliers, then that concept must come to an end. You can say yes to the minister can hear.
That is our understanding, that it will not be in perpetuity.
That was for me, Minister. Member Paul, that was for me.
Yes, it was.
Also under section 20, subsection 20 deals with the GPE's procurement protocols and rules. The OUR is recommending that the retirement of JPS capacity and any additions of new generating capacity, whether it is through a ROFO or a competitive bidding process, should be guided by the approved IRP to ensure that the generating system is developed in a consistent, structured, and economic manner. We note that the ministry, in its analysis and response to proposals from JPS with respect to subsection 7 of section 20, has confirmed that the GPE's generation capacity procurement will be informed by the IRP. So we have seen that that is the policy position of the ministry. For transparency, we suggest that this be expressly addressed in any protocols or rules that are established by the GPE pursuant to section 20, subsection 7. So while we recognize that that is not specifically for the Electricity Act, it is our proposal that that be expressly addressed in the protocols and the rules that the GPE is empowered to publish under section 20, subsection 7 of the Electricity Act. With regard to the third schedule, this is now still related, but the third schedule of the Act deals specifically with the JPS's ROFO and the conditions that must be met for the exercise of the ROFO. The OUR recommends that the generating plants that are to be replaced by JPS under its ROFO should not be done on a pari passu manner, but rather done again in accordance with the requirements of the IRP plan. Paragraph 1A of the third schedule requires that the replacement will be done in accordance with a planned schedule to be maintained by the minister. And that's the only reference to this planned schedule to be maintained by the minister. It is our recommendation that this schedule should be informed by the IRP. So the Act does not set out any any basis or any methodology by which this schedule is determined. And so it's our recommendation that it should be informed by the IRP, and that this reference to planned schedule to be maintained by the minister should have a more definitive definition, because it's very vague. Our suggestion is that it could be called something like the minister's retirement schedule for the system operator owned generating units. So our recommendation from a policy perspective is that that retirement schedule be informed by the results of the IRP, and that secondly, the reference to it in the third schedule of the Act be more descriptive, such as the minister's retirement schedule for the system operator owned generating units. The matter of compensation for easements or way leaves had come up under discussion a few meetings ago in the committee, and a member had queried what would happen if the landowner or occupier could not agree to the applicable compensation with the single buyer. Section 27 of the Act contemplates that kind of disagreement being submitted to arbitration in accordance with the Arbitration Act. But we thought we'd also throw on the table for consideration the scheme that is actually established under the Telecommunications Act. Under the Telecommunications Act, there are instances where telecommunication carriers and service providers may also need to negotiate easements with homeowners and, well, occupiers and owners of land to facilitate installation of their infrastructure and to ensure that they have access to maintain and repair their infrastructure. And under the Telecommunications Act, it actually makes reference to compensation being determined in accordance with the Land Acquisition Act. And you can find that reference under Section 54 of the Telecommunications Act. So under that act, the Telecommunications Act, the compensation can be determined in accordance with the Land Acquisition Act, or the carrier may actually seek access to land by applying to the court for an order for such access. And that would usually apply where the carrier is unable to enter into or finalize an agreement with the landowner or occupier. So it is suggested that that Land Acquisition Act mechanism could also be considered in addition to or as an option to settlement under the Arbitration Act. And under the Land Acquisition Act, it makes reference to powers of the Commissioner of Lands determining a reasonable compensation to be offered for this kind of interest in the land, which would be the way leave or the easement. And where the Commissioner's offer is not accepted, then an application can be made to the court where a judge with or without independent assessors can also make a determination as to the appropriate compensation. So we're just commending that to you as well for consideration. My final two comments relate to sections 50 and 54. 50 in relation to the System Benefit Fund and 54 in terms of the fixed penalty regime. And we do recognize that the committee has not reached there in the matrix. So Chairman, I don't know if you prefer that I hold my comments until the committee reaches there, or we raise those two now. I'm not hearing from the chairman, so I guess I will just proceed then. So section 50, there is a system benefit fund that is established under the Act, the Electricity Act, for which special funds can be established for various reasons. And a comment was submitted by Wigton Wind Farm where they suggested that the build out of transmission and distribution infrastructure should also be a beneficiary of funds under the System Benefit Fund. Their concern was that this is a significant cost to independent power producers and that they may be reimbursed all of the costs or a portion of those costs from the System Benefit Fund. The position of the OUR is that special funds such as the System Benefit Fund, which are financed through customers' bills, are designed to address issues that, if left to the market, would not be handled, would not be addressed. So, for example, a special fund was established. This is not the System Benefit Fund. So this fund would have been established before the Electricity Act came into place. But a special fund was established to finance the conversion of the JPS's Bogue plant to a dual fuel plant, which facilitated the introduction of natural gas as a fuel source into the electricity sector. As the cost of the fuel pass-through goes straight to customers, so JPS is not significantly impacted by what that cost may be, there would not have been a real incentive to JPS to fund such a conversion and then advance the benefits that would accrue to the sector through fuel diversification. Similarly, there's not much incentive to the single buyer to rapidly introduce LED streetlights, because you can imagine with the rollout of LED streetlights, these are more energy efficient. They will use less kilowatt hours, so that can impact revenue streams. And so in both of those instances, special funds had been established through a line item on customers' bills, so that these interventions could be done and the benefits accrued to customers. So special funds are market interventions that should only be used when it is absolutely necessary to be a benefit to the wider market and where the market itself cannot provide incentive and compensation for these things. So the suggestion that a special fund be used to finance infrastructure that's required for the electricity supply from IPP is unusual, because it's our understanding that that can be dealt with by the market and it would be recovered by way of the tariffs that the IPP would be allowed to charge for supply of services. My team says that you would apply the cost causation principle in the development of the applicable tariffs, so that recovery is done by that means. And where IPPs are selected via a bidding process, the inclusion of these costs actually contribute toward the competitiveness of the outcome. So it is our view that the proposal from Wigton should not be favorably considered. The System Benefit Fund and any other similar fund should not be applied to this purpose.
And if I can just make one point.
Yes, partly.
On the issue of the transmission or probably distribution costs. And specifically, I think that relates to interconnection. So whether it's a renewable plant or a conventional plant, whichever, I mean, interconnection costs or interconnection arrangements are a standard feature of most private power projects or generation projects. So those costs must be incorporated in the levelized tariff that is put forward for such projects or proposals. To accommodate such an intervention where costs are being borne by the System Benefit Fund to facilitate an IPP is not prudent and is not consistent with prudent utility practice. Thank you.
Thanks for that. A lot more eloquent than I could have put it. And our final comment relates to section 54, which deals with the fixed penalty scheme that is set up by the Act. We had made a recommendation that the ministry and the committee examine the various offenses that are provided for under the Electricity Act and expand the fixed penalty listing of offenses. I think only about 3 are listed now. And so that be expanded so that this kind of traffic ticket type regime can be applied to more offenses that are considered or contemplated under the Act. In its recommendation, so I'm preempting the ministry now, because as I said, the committee has not reached this one, but in its recommendation, it is proposing that the OUR provides some specificity for the proposed penalties. We are prepared to provide recommendations, but we just want to put on the table that we recognize that this will involve extensive research on penalties that obtain under similar legislation, both in Jamaica and elsewhere, or that obtain for similar offenses. And there may also be cross-sector considerations within Jamaica in determining what would be appropriate penalties. And so we recognize that there may be other entities that have as their primary function that kind of legislative review and research, who may be better positioned to conduct the necessary examination or analysis. We also do recognize that in the circumstances, any such proposals that come up may need to be the subject of review by others with greater legislative expertise and a wider view of the legislative landscape. So we say all of that to say that we would certainly wish to participate in that kind of discourse and discussion, but we may not be well placed to do that kind of research and make submissions in a timely manner, bearing in mind that the committee is almost at the end of its deliberations. So for us to make that kind of submission, we would need a bit more time. And that is basically the sum total of the written submissions that we have made to the committee at this time. Thank you for the opportunity.
On that last point, Ms. Riley, because it is true that we oftentimes enshrine into the main legislation penalty provisions, and invariably, especially with these laws being there without review, the penalty provisions become outdated. Have we seen where there are other models which allow for penalties to be shifted to subsidiary legislation subject to affirmative action to enable periodic review without a comprehensive review of the legislation itself, but as subsidiary legislation?
Yes, actually, it has not been actioned as yet, but under the Telecommunications Act, I believe the offenses and penalties can be done by order of the minister, rather than being enshrined in the actual substantive or the primary legislation.
Yeah, I'd recommend that in this case as well. Over to you, Chairman.
Noted, noted, noted. Thank you very much for that extensive presentation. You would have noticed that Member Paul was in agreement with you on almost everything, so that's a good sign between OUR and a Member Paul. So I will come back to you. Member Paul on the other matter. Remember reminding the OUR and Ms. Campbell to follow up to get the document in relation to the other matter for me. And we're going to go straight in now to the continuation of the Electricity Act, the review of the matrix. We are now at, we did 35 to 46. So you're going to move on from 47 now, Ms. Campbell?
Minister, I was intending to go back to the request of the committee regarding highlighting the provisions which specifically references the single buyer.
Mm-hmm. Okay. You want to do that first?
Yes.
Go ahead.
But before I go, if you would permit me to respond to a few matters based on the OUR's presentation. So we will not comment on section 50 nor 54. As you will appreciate, the ministry has not presented its position to the committee. In relation to section 20, concerning the provision which prohibits the subsidiary of the single buyer from exercising the ROFA directly on behalf of the single buyer, the ministry's position is not at odds with the OUR. I believe there was an error in translation. We do not recommend the removal of section 20 subsection 5. We actually, we suggested if there is any ambiguity, then perhaps the language could be made stronger to be clearer that the subsidiary of JPS cannot exercise a ROFA directly. In relation to the section 20 subsection 7, from our perspective, the GPE is guided by the IRP in relation to procurement and also in relation to the ROFA. We do not know how the GPE would actually perform its functions if it's not related to the policy outlined in the IRP from the system planning functions. But we do accept, and the GPE, as far as we're aware, is aware that they are guided by the IRP. In relation to the third schedule on the right of first refusal, we do not agree that the reference to the minister's retirement schedule should be specifically stated. In relation to that, the paragraph 1A already says that there's a schedule that is maintained by the minister. There is a reference to this in the IRP, and we are aware in relation to section 20 also that it is the retirement schedule that the right of first refusal applies to, and that is also why in relation to the provisions in the license also, in the JPS license, that this is a special requirement. And in relation to the replacement of those outdated generation sets, they have first preference if they follow the stipulations for the exercise of the ROFA. And that would conclude my
Ms. Campbell, just on that point, I'm trying to understand, because I heard Ms. Riley to have said earlier that the right of first refusal, firstly, it can't be in perpetuity, but then who exercises that right? Is it the Jamaica Public Service Company as we know it, or can private power suppliers operating under the auspices of some of the shareholders in JPS, can that right be transferred to them, as we've seen in at least one case so far? Is that the interpretation that ought to be given? Because a right of first refusal was granted to the Jamaica Public Service Company, and we know who that entity is. The other entities that are coming to act on behalf of JPSCO are new enterprises. I think the ministry has to take a position on that.
The ministry's position, Member Paul, is guided by the law, and the law specifically states that the JPS should exercise the role for directly. Now, there might be circumstances, and subsection 8 represents an exception where the JPS may exercise it through a subsidiary on terms that the GPE considers appropriate. So that, in our estimation, is the exception, in the sense that the JPS would be exercising the role for through a subsidiary, but we understand it to be that where the JPS does that, it is still the JPS that is exercising the right of first refusal. Otherwise, by virtue of subsection 5, then the subsidiary, if it is going to do it directly, then that would be barred, and the matter taken to a competitive process.
Well, as the minister is aware, that's one of the controversial issues that would have arisen during this process, whether or not going forward that is going to be a facility that is recognized. And I think we have to have a separate, distinct discussion on that, because I think at one time the majority of the members felt it was an anachronism that we could do without at this stage.
I'm sure the minister, I wouldn't speak for the minister, but I'm sure that will be part of the consideration when looking at the market structure.
Minister,
Yes, sir.
yes, just in terms of the schedule for the rest of the afternoon, do you have an idea as to what time we will find it convenient?
You want us to go to 4?
Okay, very well.
Ms. Campbell, give me an idea where we are now in terms of we set 2 more meetings. I think my understanding is that Parliament will recess for the summer on either the 18th or the 25th, depending on what outstanding business has to go to Parliament. But that doesn't preclude us from meeting. And we had set for the 19th and the 25th after today. Based on where we are now, Ms. Campbell, do you think that we can conclude by the end of the session on the 25th?
And when you say minister conclude, do you mean to have a report?
The matrix, no.
Okay.
Conclude the matrix.
Okay, because certainly we won't have a report by then.
Yeah, no. Absolutely. I mean, once we finish the matrix, I mean,
Okay.
obviously we know that by the time we get back to Parliament, we can have the report and of course, obviously conclude. But I just want to know the timelines because after the 19th and the 25th, if we need to go later, I mean, go for a longer period, and I'd want to plan it and give members notice from now. So that's why I'm asking now. We have two more dates that we have blocked. So give me an idea, Ms. Campbell, where we are now in terms of the matrix.
So, Minister, we would need to proceed afresh from section 47. But I will I'll indicate that there were some sections that we skipped relating to the single buyer. There's section 45 related to the system operator that was also skipped because there is a nexus with the single buyer discussion in relation to that, and also the concept.
All right, let us not take up the time today. At the end of this session, basically, you will do a review of it and give me an idea as to what kind of timelines we need, so that I can try and see whether we can fit it in for the 19th and the 25th, and if we have to go longer, give the members notice so that they can plan their schedules, and we try and wrap it up.
Certainly.
Okay, go ahead.
So the committee asked 2 meetings back for the ministry to highlight the specific references to the single buyer in the Electricity Act. And we've gone through and we've highlighted them here with a few comments. Now, we were also advised that it might also be prudent to highlight the definitions in which the expressed phrase, the single buyer, appears. Now, so we will begin with the interpretation section. The independent power producer means a licensee that owns or operates facilities for the generation of electricity for use primarily by the public, and that it is not the same legal entity as the single buyer. The definition, and I'm just going to highlight a few comments. The definition here recognizes that the independent power producer is a licensee, and it is not the same as the single buyer. A licensee is defined as the holder of an electricity license. Now, it is important to note that any person having an electricity license, including the single buyer, is a licensee. A self-generator with a net billing or wheeling license is also a licensee, and an independent power producer is also a licensee. Net billing means a mechanism for self-generators to sell or otherwise be credited with the value of the excess power generated under a standard offer contract with a single buyer that had been approved by the office. So this recognizes that a self-generator is a net biller, and the net biller enters into a contract to sell the excess power to the single buyer. So the single buyer and the net biller / self-generator is not one and the same. A power purchase agreement means the contract that governs the commercial relationship between an independent power producer, as mentioned above, and the single buyer. And you may recall that the single buyer purchases power from the independent power producer, and that contract is approved by the office. So it's only the single buyer, by the definition of the term single buyer, is authorized to purchase power from an independent power producer. And the arrangement governing that purchase is the power purchase agreement. The system operator is defined as the licensee holding the dispatch license that is a ring-fenced department within the single buyer. The license for dispatch activities is to be held by the system operator based on the definition here. And the system operator is a ring-fence department within the single buyer and not any other licensee. The single buyer is defined as the licensee whose license obligates it to purchase electricity generated by independent power producers and persons having net billing arrangements. So the article, although it may refer to one or more nouns, the single buyer, we're of the view that the fact that there is the word single may operate to limit the number of buyers and may be intended for a specific reference and not to any other licensee, although the single buyer is a licensee. In section 5 that deals with directions of the office where it considers necessary may give directions to any licensee with a view to ensuring that A, the needs of the consumers of the services provided by the single buyer are met, and B, the single buyer operates efficiently and in a manner designated to protect the health and well-being of users of the service and such elements of the public as would normally be expected to be affected by its operations. 2, protect and preserve the environment. And 3, afford to its consumers economical and reliable service. In our interpretation, we recognize that although the single buyer is a licensee, for the purpose of this provision, the single buyer is given specific reference in relation to its responsibilities within the current market structure. And there is a distinction between the single buyer and a licensee generally, because as you can appreciate in the leading sentence, the office may give direction to any licensee to aid the single buyer in performing its responsibilities in relation to the Electricity Act. We move to section 6. Section 6 deals with the standards of the single buyer. And you may recall that it was mentioned earlier by the OUR. And the standards here are related to the single buyer specifically and not to all licensees. We may consider whether or not we need to have, if the committee determines that the single buyer phrase should be dispensed with, whether or not we would need to have buyers or just have one nomenclature, licensees for every activity under the Act in respect of which a license may be granted. In section 7, which deals with system planning requirements, and which is the responsibility of the minister. The minister shall be responsible for planning the development of the system, which planning shall include the integrated resource plan, the collection of data from electricity sector participants, consultations with the office, the single buyer, and other electricity sector participants, the conduct of any relevant forecast. We recognize here that there is an obvious reference to the single buyer in relation to consultation. We do recognize that the single buyer is an electricity sector participant from whom data can be collected. But we note at subclause C that the consultation singles out and expressly references the single buyer as a party to be consulted with, and also mention other electricity participants. And we consider that the reference there is deliberate. In section 13, which deals with revocation or suspension of electricity license, we note that there's only a reference to the single buyer at subsection 6. And it says, where the licensee is a party to an agreement with a single buyer for the sale or other supply of electricity to the single buyer, a breach of that agreement by the licensee or the single buyer shall constitute a breach of the electricity license held by the licensees or the single buyer, as the case may be. We've observed from that provision that the single buyer and licensee are given separate reference. We move to section 18, and this section has provisions concerning self-generators. And at subsection 2, the law prescribes that the self-generator who intends to sell excess electricity that it generates should enter into a contract with the single buyer. And in that respect, we have noted that the self-generator / net biller / licensee is distinguished from the single buyer. Section 19, independent power producers. I'll read a portion. It says, subject to subsections 2 and 3, the single buyer shall enter into a power purchase agreement with each independent power producer. And the single buyer shall not be obligated to connect an independent power producer's generated electricity output to the system unless both the single buyer and the chief electrical regulator agree that the independent power producer's connection will not compromise the safety and protection of the system. We may also reflect on the fact that the definition of independent power producer distinguishes the IPP from a single buyer, and it is evident in this provision also. Section 20, the single buyer is referenced in a number of the subclauses, and it deals with the procurement of new generating capacity, but also the exercise of the right of first refusal. And this is a special right given to the single buyer existing. This right cannot be transferred to any other licensee, and this right is also expressed in the JPSCO Electricity License 2016 as amended. Section 23, in section 23, we see in reference to the removal, the installation of electric line, there's a reference to the single buyer or a self-generator. Notwithstanding anything in this act, the single buyer or a self-generator shall not place or move any transmission line or distribution line above ground, underground, along, over, across any street without the express written consent of the local authority. And the local authority may require the single buyer or the self-generator to forthwith remove any transmission line or distribution line placed by them contrary to the provisions of this section, or itself remove the transmission line or distribution line, or B, recover the expenses of such removal from the single buyer or self-generator by civil proceedings without limit of amount in the resident magistrate's court of that parish. Now here, based on our interpretation, it is accepted on the face of it that there is intended to be a distinction between the single buyer and the self-generator as a licensee. We accept, though, as a preliminary point, that the proper reference ought not to be to a self-generator. And previously, in relation to a comment to the Joint Select Committee, the ministry indicated that in that respect, the removal of the reference to self-generator is not challenged. And in that submission of the position to the Joint Select Committee, we did indicate that licensee may be substituted for self-generator because it's possible that a licensee that's not a self-generator may need to carry out those activities. And we suggested that the single buyer express mention be retained and a licensee be substituted for the self-generator. That recommendation is also applicable to subsection 24, and in subsection 24, the court, the parish court, has jurisdiction in relation to the safety of the public in relation to making orders concerning the electric lines or electricity lines. In section 25, which deals with way leave agreement, the section says nothing in this act shall preclude the single buyer and the owner or occupier of any land from entering into an agreement for laying, placing, or carrying on under or over such land any supply line, posts, or apparatus here referred to as way leave agreement, or affect any way leave agreement subsisting on the first day of October 1958. In our consideration, we note that by history, these activities would primarily be concerned with the single buyer. But we appear to consider that if the committee determines that the activities under this act, the main activities ought to be subject to competition, and if in that case, any licensee would have the opportunity to enter land for the purpose of supplying electricity, then there is no objection to the provision expanding to include licensee other than the single buyer. And following from that section, if it is that other licensees other than the single buyer are given the right to enter into these agreements, then the right of arbitration should be accessible as well. And that's in relation to section 27. We move to section 29, right of entry to premises for inspection. And here an agent appointed by the single buyer is given the right of access for inspection or maintenance of meters, accumulators, fittings, works, or other property belonging to the single buyer is the wording for the purpose of maintaining. If it is that the committee considers that in the availability of competition for the main activities, then any other category of licensee may be added to this. But in order to maintain the current status quo, it should be considered that the appropriate reference be made so that the single buyer is captured here. Section 30, offense of obstructing an agent of a single buyer. The same reasoning applied as in section 29 above. In section 29, you will recall that an agent of the single buyer is given right of access to maintain apparatus and other equipment of the single buyer in relation to the supply of electricity. So if supply is subject to competition and other licensees admitted, then the reasonable proposal then is for any agent of those licensees, authorized agent, to be given right of access. They would be protected if they are obstructed in the same way the agent of the single buyer is protected. Section 32, right of easement of the single buyer. The single buyer has the right to enter land, lay or remove, place, or carry on under or over any land except land use as garden, park, or pleasure ground, or land being the curtilage of dwelling house or other similar land in the immediate vicinity of any building. Such supply lines, poles, and apparatus as are necessary or convenient for the safe supply of electricity in accordance with the relevant license. It is considered that if a license is granted, if the decision is taken for supply element, for example, to be extended to other participants in the electricity sector, then this right to enter land where they have equipment or other implements used for the supply of electricity, then the right of access by way of easement may also be considered. Section 33, following on the easement, deals with compensation, and if the decision is taken to so extend the right of access to other licensees other than the single buyer, then it follows that they would be eligible to make compensation where their entry causes damage to any person. Notice to owner of land. This section deals with the requirement for the single buyer to give notice, prior notice, not less than 21 days before entering any land for the purpose of doing any work thereon by virtue of rights conferred under this part of the Act. and the single buyer shall give the owner notice in the prescribed form of the work proposed to be done on the land. It is reasonable that a licensee other than the single buyer who may require to enter land for any purpose consistent with any license granted for supply, transmission, distribution of electricity would need to submit to this requirement and give notice as required. Section 35 concerns joint use of poles. It says the single buyer may enter into any arrangement or contract for the joint use of poles, and if the public interest so requires, the office may direct the single buyer after consultation with the single buyer to use any poles jointly with any other person, so long as such use shall not contravene any law. We understand that the poles are owned by the existing single buyer, and for that reason, we feel that the express mention of single buyer should remain in relation to this provision, and because we are of the view that the language here acknowledges that the single buyer owns the poles. And it may be that if there is a decision for the current structure or model to be changed, that there might be an allowance for other poles to be installed. So it may also require an adjustment to the provision, recognizing that there may be need for agreements with other persons who owns poles with other persons who may need to use such poles. But generally, we are of the view that the language here acknowledges that the single buyer owns the poles, and the express mention of the single buyer should be retained as a primary consideration. Section 36 has provisions for fair compensation for use of poles. Said it shall be a condition of any direction given by the OUR that the single buyer shall receive fair compensation for the use of poles by any other person as may be agreed, or if the parties fail to agree, fixed by the office. The reasoning that we applied in section 35, which is connected to this provision, that the express mention of the single buyer should remain for the reasons we've stated above. Section 37.
Ms. Campbell, how many more sections do we have to go through?
We have up to 40.
We're at 4 o'clock now.
We're at 4. We have up to 50 to the third schedule, beyond 58.
Yes, and to be fair to you, but what you have done is just to identify where the concept is used. And I think that is not the issue, that is to identify where it is relevant, but rather for the policy maker to come back to us to say whether or not we're going to retain this concept, which is quite limited, and or rather to enhance it by enabling the law to provide for a different scenario when 2027 comes. But Chairman, I think in light of the schedule that we're on now for 4 o'clock, we might want to call it a convenient time.
Yeah, agreed. So what I will do, members, is I'm going to ask Ms. Campbell to review where we are and what is outstanding and then give me feedback in relation to what she thinks would be the appropriate time that would be needed in terms of hours. Because at this late stage, obviously, we don't want to rush it through to meet up meet necessarily the parliamentary recess if we're not there. Obviously, that would be ideal, but obviously we don't want to rush and miss any other gaps. So what I will undertake to do is to get back to the members in the coming days, probably by Friday or early Monday, in relation to where we are, what is outstanding, what was skipped, what sections we still haven't gotten to, and then obviously we have 2 meetings set for the 19th at 2 o'clock and the 25th at 10 a.m. And maybe we can set from beforehand some extended time, maybe from 2 to 3 hours, if necessary. But I will be guided by Ms. Campbell when she comes back to me on that. But yes, I think we can pause here for the day. So thank you, members, for your participation, and you will hear back from me. But as of right now, we had agreed on the 19th at 2 o'clock and the 25th at 10 a.m. So I'll now adjourn the meeting until the 19th at 2 p.m. And I'll just remind Ms. Campbell to follow up those matters that I discussed in my opening comments and to seek to get that document from the OUR in short order, so we can also respond to that before we close off.
Sure, Minister.
All right. Thank you again, members. Thanks to all the supporting agencies, and be safe until we meet again on the 19th.
Okay, Minister.
Recording stopped.